Słyszycie mnie, Bartek? Jesteście? Julka?
Tak, słyszymy, wszystko jest w porządku, możemy zaczynać.
No dobra, to co, zaczynamy, tak? Tak, Julka?
Tak, możemy zaczynać.
Dobra. Poczekajcie sekundkę, tylko wyłączę, żeby mi tu nikt nie przeszkadzał. No dobra, lecimy to. Ladies and gentlemen, I'm welcoming very warmly to the one of the dissemination event in the framework of our researchers lead with our partners with the Central European Academy. This dissemination event is devoted to the migration and migration issue and legal response for this phenomenon. My name is Marcin Wielec, and I am the director of the Institute of Justice in Warsaw and the vice dean of the Faculty of Law and Administration in the University Cardinal Stefan Wyszyński in Warsaw. And it's my pleasure, my honor to open this event. This event is a HARD-TALK with participation with the young researchers. And I only mentioned that this event is the dissemination event by the Dr. Bartłomiej Oręziak as the participant of our professors network, led by the Central European Academy. And in this program, I only mentioned that I am the head of one of the groups. This group is devoted, and the name Migration Challenges, Legal Responses. From my side is all. I wish you fruitful deliberation, fruitful thoughts, and pleasure from this discuss. Thank you very much.
So thank you very much, dear Professor Wielec, for introduction, for opening my dissemination event. It is a great honor for me and privilege. Thank you very much. And indeed, ladies and gentlemen, I also would like to welcome you to the dissemination event entitled HARD-TALK on Asylum and Refugees Legal Affairs. My name is Bartłomiej Oręziak, and I am a member of the Central European Professors Network 2023, exactly in the research group Migration Challenges, Legal Responses, headed by Professor Wielec. I am also in the Institute of Justice in Warsaw, the coordinator for the Center for Strategic Analysis and the assistant professor. It is a real honor for me that I can conduct this HARD-TALK as dissemination event in Central European Professors Network 2023. So we all know we all know that asylum and refugees affairs from legal point of view are important. Everyone knows that. That is why it is also important to analyze this, show different faces, various problems, and ask questions. As part of this event, there will be questions from my side to participants and to our guests. So there will be two panels. First, it is Refugee Legal Affairs, and second, it is Migration Legal Affairs. Now, because I believe that this is a very important part of the event, I would like to introduce our colleagues, our participant of the HARD-TALK, who will take part in our event on asylum and refugee legal affairs. So the first, it will be the Julia Starybrat, a final year law student at the Faculty of Law and Administration of Cardinal Stefan Wyszyński University in Warsaw, currently the president of the Scientific Association of Criminal Trial Law and member of the didactic committee at the Faculty Law and the Administration of Cardinal Stefan Wyszyński University in Warsaw. Her main interest focus on issues related to criminal law and criminal procedure, protection of human rights and European Union law. The second participant is Tomasz Bojanowski, lawyer, currently a PhD student at the doctoral school at the Cardinal Stefan Wyszyński University in Warsaw, and so also graduate of law at the same Faculty of Law and Administration of Cardinal Stefan Wyszyński University in Warsaw. And what is important here, winner of the scholarship of the Minister of Science and Higher Education for outstanding achievements in science for the academic year 2021-2022. Main interest of Tomasz is criminal law, criminalistics, protection of human rights, constitutional law, administrative law. And third, last but not least, is Agata Wróbel. She's a law student at the Faculty of Law and Administration of the Cardinal Stefan Wyszyński University in Warsaw, multiple winner of the Rector's Scholarship for the Best Students, member of the board of the Scientific Circle of Procedural Criminal Law and the Scientific Circle of International Law and Human Rights of Cardinal Stefan Wyszyński University. Her research interests include new technology law, artificial intelligence, intellectual property law, civil law, and that's it. So, ladies and gentlemen, I have to set one more information that it should be one more speaker, but from the last news, unfortunately, Victoria cannot join our event. So now we are going to start our discussion. Let's talk on the rights under the asylum and refugee affairs. So, ladies and gentlemen, my first question is what rights do refugee families have in Poland? And this question is for Tomasz. Yes.
Maybe
sorry for. Sorry. So Agata, please, if you could answer for my first question, what rights do refugee families have in Poland?
Yes, thank you. So, ladies and gentlemen, Poland is one of the Central European countries attracting foreigners with its many tourist attractions, historical monuments, picturesque landscapes, mountains, lakes, and the sea are frequently a reason for visiting our country. So, unfortunately, not every trip to Poland is of tourist nature. Some foreigners come to Poland in search of protection and better living conditions, fleeing conflicts, persecution, or difficulties in their countries of origin. As a result, they have to leave behind loved ones and familiar places, uncertain when and if they will be able to return to their home at all. When refugees arrive in a new country, they should, in a short period of time, get to know completely different culture, traditions, customs, and as well as familiarize themselves with the applicable laws and common values of the society. This is not because of their own decision, but because of they have to build their lives again in places that are completely foreign and difficult to understand for them. Over the past 20 years, Poland has transformed itself into a country that actively accepts refugees. During this period, dynamic changes can be observed both in the number of foreigners applying for the refugee status and in the diversity of their countries of origin. The right of refugee families on the territory of Poland are regulated by both international refugee standards and the national legislation of Poland. Proceedings for granting international protection are conducted in accordance with the principles set out in Act on Granting Protection to Foreigners within the territory of the Republic of Poland of 2003. A foreigner is granted the refugee status if due to justified fear of persecution in the country of origin, on the grounds of race, religion, nationality, political opinion, or membership of a particular social group. So he or she, because of these reasons, cannot or don't want to benefit from the protection of their origin country. Foreigner is granted subsidiary protection when returned to his or her country of origin, threatens him or her with the risk of serious harm, or there is a serious and individualized risk to life or health associated with widespread violence in a situation of international or internal armed conflicts. Because of this risk, the foreigner cannot or doesn't wish to benefit from the protection of the country of origin. The next important right, in my opinion, is guaranteed access to healthcare, including primary care. The state is obliged to ensure equal access to healthcare system in order to protect health and life. Refugees have the right to equal treatment and protection from various forms of discrimination, regardless of their origin or religion. Equal treatment means that refugees and their families have the right to participate in all areas of social, economic, cultural, and political life under the same conditions as citizens of the host country. Equality and non-discrimination are fundamental values whose observance is crucial for the fair and human treatment of refugees. As for the children of refugees, they have the right to education on the same terms as the children of Polish citizens. Polish public schools open their door to refugee children, which is important step in ensuring their access to a fully fledged education. While in Poland, refugee children can benefit from the educational resources available in the Polish school system, enabling them to develop their skills, acquire knowledge, and establish relationships with their peers. At the same time, this approach emphasizes the value of education as a universal right of every child, regardless of their background or migration history. Thank you.
So thank you very much. In the fact that it's a very important issue related to the, I will say, family rights, especially children's rights in the scope of regulation. In fact, there are some important regulations in European Union law. So I'm talking about the procedural reception and qualification directives. So thank you very much, Agata, for this question, for this answer. In fact, this bring a lot of important information in this regard. So the next question is for Tomek. Tomek, maybe you can set us how is the concept of the refugee defined in international law?
Yes, thank you. And I need to start with the term refugee and migrants because they are increasingly used as a synonymous in the media and in the public discourse. And it's there's a fundamental difference between them of the legal nature. Confusion between these terms can lead to problem affecting the refugee and asylum seekers, as well as a confusion in the discussion on asylum and immigration. And what distinguishes the refugees? The term of refugee is clearly defined in international law, which provides the refugee with the protection. Refugees are the person who are outside their country of the origin due to the fear of the persecution, conflict, violence, or other circumstances seriously disturbing the public order, and who, as a result of the above, require international protection. They are often in such a dangerous situation that they cross national borders to seek safety in the neighboring countries. Thus, they are recognizing internationally as a refugee person who are entitled to assistance from the other states, so the United Nations and the relevant organization. They are recognized as a refugee precisely because it's too dangerous for them to return home, and they therefore need a refugee elsewhere. There are individuals from the home denial of the asylum has potentially fatal consequences. And how are refugees protected under the international law? The specific legal regime protects the right of the refugee is called international refugee protection. The need for this regime stems from the fact that the refugees are particularly vulnerable persons in the need of the additional resources. Asylum seekers and refugees are deprived of the protection of their country. The Article 40 of the Universal Declaration of the Human Rights grants every human being the right to seek and enjoy asylum. However, the concept of asylum did not have the clear definition at the international level until the 1951 Convention relating to the status of the refugee. It was adopted by the United Nations and was entrusted with the overseeing the implementation. The convention and the protocol, as well the regional legal instruments such as for example, Organization of the African Unity Convention governing a certain aspect of the refugee problem in Africa, for example, are the cornerstone of the modern refugee protection regime. They provide a universal definition of the refugee and define the basic rights and obligations of refugee. So the provision of the convention remain the main international standard underpinning the assessment of the all protection measure and treatment of the refugee. Its most important provision, the principle of non-refoulement, contained in the Article 33 of the cornerstone of the aforementioned regime. According to this principle, refugee must not be expelled or returned to places where their lives or freedom would be threatened. States of the primary responsibility of the such a protection. United Nations works closely with the governments, advising and supporting them as a necessary implementation of their responsibilities. So, the Convention and the Protocol have saved a million lives, and such as the one of the key human rights is the key human rights instrument. The Convention is milestone of the humanitarian law, developed in the aftermath of the mass movement people exceeding the size even what we see today. At its core of the Convention represents fundamental humanitarian values. It has clearly demonstrated a capacity of the adapt changing factual circumstances being recognized by the court and of the living of the thousands of refugees. So the biggest challenge regarding refugee protection is certainly not the convention itself, but rather ensuring that states comply with the provisions. The real need is to find the more effective ways to implement this provision and spirit international cooperation and responsibility sharing. So thank you.
So Tomek, thank you very much for this that you add this distinguish between the migrant and refugee. It's important issue, the problem, and I have to say that you strike in the ten because our head of the research group, Migration Challenges, Legal Responses, write a chapter on this topic, the notion between refugee and migrant. So thank you very much, and I think that it was quite important to hear about the definition of the refugee. So I have the question for Julia, if I may, of course. I would like to ask you which specific areas of migration law are regulated at the European Union level and which are left to the discretion of the member states in accordance with the principle of conferral and subsidiarity.
Thank you very much for your question. So the issue of migration constitutes a significant aspect of both EU policy and the policies of its member states. It is crucial to analyze borders and the principles governing the competencies of the European Union in the field of migration and refugee law. The principle of conferral forms the foundation for EU competencies. This occurs because the competencies of the EU are delegated by sovereign states, guaranteeing their own authority. This is expressly provided for the primary law of the EU. In the case of migration law, this implies that the EU should intervene only when member states are unable to independently manage the flow of immigrants and migration with their authority. The principle of subsidiarity operates only in areas that do not fall within the exclusive competences of the EU. Decision regarding the issuance of visas or work permits for migrants can be made by member states as they depend on the specific needs and conditions of each country. The general division can be presented as follows. Visas policy: over 400 million EU citizens have the right to freely move within the Schengen area. They can travel, work, and reside anywhere in the EU. The right to free movement also applies to a third country nationals residing in or visiting the EU as tourists, entrepreneurs, or students participate in exchanges. Asylum policy: the EU asylum policy aims to grant appropriate status to any non-EU citizen requiring international protection in one of the member states and ensure compliance with the non-refoulement principle. As a result, the Union seeks to establish a common European asylum system. Immigration policy: the primary goal of the European Union is to develop a forward-looking and comprehensive European immigration policy based on solidarity. Immigration policy aims to ensure a balanced approach to both legal and illegal immigration. Border control: the European Union collectively manages the Schengen area. This is an area where border controls have been abolished and internal borders between member states and specific uniform rules regarding external border controls are applied. All these elements contribute to coherent migration policy whose objective is to effectively manage the flow of migrants and maintain principles of cooperation among EU member states. Thank you so much.
So, Julia, thank you very much for answer. And this question is, it was my intention to ask you because my research in the research group of migration challenges, legal responses are familiar with this issue of the proportion about the powers, competences of the European Union and member states, especially in migration and refugee law, as we all know that this is there are shared competences under the treaties. So thank you very much for this question. In fact, for this answer. At the end of this panel, I would like to go back once again to Agata Wrubel and ask you, Agata, what practical applications of artificial intelligence can support the process of asylum and integration of refugees in host societies, host countries.
Thank you very much for that question. Extremely interesting for me. Firstly, language barriers, ladies and gentlemen. Language barriers often pose a substantial obstacle to refugees seeking asylum. AI-powered language learning applications can play a crucial role in addressing this challenge. These platforms offer personalized language courses, utilizing natural language processing and this machine learning algorithm to adapt to individual learning styles. By accelerating language acquisition, refugees can more effectively communicate with the local population, navigate daily life, and integrate into the community. We can even mention the possibility of simultaneous speech translation into any languages, thanks to artificial intelligence tools. Often it is difficult to quickly find interpreter for a particular language. So in order not to lead to ridiculous situations like with Tom Hanks from the movie The Terminal, we can use AI tools. Employment is also a vital aspect of refugee integration, and AI can contribute by facilitating the matching of refugees with job opportunities. AI algorithm can analyze refugee skills, qualifications, work experience, and positioning them to appropriate employment options. This personalized approach enhances the likelihood of refugees securing meaningful employment, fostering economic sufficiency, and promoting social integration as well. In the realm of mental health support, AI can also address the psychological challenges which are often faced by refugees. Maybe it's some sort of speaking about the future, but chatbots and virtual mental health assistants using AI technologies can provide accessible and culturally sensitive mental health resources. These tools offer a confidential space for refugees to address trauma, stress, and other mental health issues, helping them cope with the emotional toll of displacement and fostering overall well-being. As we know, administrative processes related to asylum application can be complex and time-consuming. AI can streamline these procedures by automating documents processing, like data verification and case management. This not only accelerates the asylum seeking process, but also reduces the administrative load of the both refugees and host countries, ensuring a more efficient and transparent system for everyone. Education is another crucial component of successful integration. AI-driven educational platforms, such like these language ones, can offer personalized learning experiences, which can be customized and prepared for individuals. This not only facilitates academic achievements, but also equips refugees with the skills necessary for social and economic integration. To sum up, the practical application of AI in language learning, employment, mental health support, administrative process, and education can collectively contribute to a more effective and humane integration process for refugees in host societies. By joining the power of AI, we can address the unique challenges faced by refugees, promoting their self-sufficiency and enhancing their ability to rebuild their lives in a new community. Thank you.
So thank you very much for this answer and question, and the answer touch the current, in my opinion, very hot topics of use of modern technologies in practice in the scope of artificial intelligence, focused on the challenges of migration and asylum affairs. So very interesting for me personally also. Answer, and thank you very much for this, Agata. And now we are going to the second panel of our HARD-TALK. This is Migration and Legal Affairs, as previous one was Refugee Legal Affairs. So the first question in this panel, in fact, and this is not in this time a mistake, I hope, is going to the Tomek. So Tomek, I would like to ask you, could you give me of course, give us an overview of migration policy in the European Union?
Okay, thank you. So the European Union and of course its member state are intensifying the effort to develop an effective, human and secure European migration policy. The European Council of Europe plays an important role in this effort by setting strategic priorities. On this basis, the EU Council clarify modus operandi and gives a mandate for the negotiation with the third countries also adopts legislation and defines the specific programs. In recent years, EU Council, European Council developed a strong response to the migration pressures. And important to point the specific instruments that EU migration policy, this means asylum policy, legal migration, combating irregular migration, and the institution, the global approach of the migration and mobility, and the European migration network. So let's start. EU asylum policy is currently the most rapidly developing areas of the area of the freedom, security, and justice. One of the pillars is the common European asylum system, and the aim of this system was to harmonize the legal framework applicable to the member state in the field of the asylum on the basis of the common minimum standards. The aim of the second phase was to create a common asylum procedure and the uniform protection status. The proposal for few acts were complemented by the innovative practical cooperation, solidarity, and the external dimension of the asylum and the migration. Next, the legal migration, as opposite of the illegal migration, is characterized by the fact that the alien's entry and stay in the country is lawful, and the alien is questioned has the necessary documents to legalize the stay. The condition of the entry and stay, as well as the employment, are strictly defined by the law. Therefore, this type of the migration covers issues related to the legalization of stay, labor migration, as well as the issues related to the integration of the foreigners into the host society. When it comes to the tackling irregular migration, the European Union, together with the member states, is working hard to prepare the effective response to the migratory pressures at the EU external borders, for example, the Poland borders. In view of the unprecedented scale of the phenomenon, of the European Commission has proposed a number of the measures to address the current crisis. The most important instruments include the resettlement of the relocation programs and EU action plan to combat migrant smuggling, and EU return plan action, and of course the EU common list of the scale of the countries of the origin. And the next is the global approach of the migration and the mobility. Is a concept of the established framework of the external dimension of the EU migration and asylum policy, according to which EU cooperation with third countries on the above mentioned issues is carried out. The GAM is composed of the four pillars, which define a priority of the dialogue of the cooperation with the third country from the migration perspective. So the thematic areas of the GAM are legal migration and mobility, irregular migration and counter trafficking in human beings, promoting international protection of the enhancing the external dimension of EU asylum policy, and the last one, the interaction between the migration and development policies. So the last one is the European Migration Network. It was established by the decision of the EU. Its main objective is to meet the needs of the Union institution of the member states authorities and institution of the up-to-date, objective, reliable, and comparable information of the migration asylum. This information is indeed to provide the starting point of the policymakers and experts at the national European level to better understand the current challenges of the field of the migration, including in particular to assist the European Commission in deciding whether further action is needed to European level. So it is what EU migration policy looks like, and whenever it's effective or it's another matter, each of you can judge for yourself. So thank you.
So thank you very much. At this time, the policy on migration across within the European Union and the European bodies are very interesting and important problem, especially to learn and show how we could learn from the previous years about the migration crisis in 2018, 2019, for example. Julia, for you is the next question. And I would like to ask you, what are examples of actions taken at the European Union level within the framework of the principle that you discussed earlier, and how do they affect the protection of refugee rights?
So at the European Union level, various actions are taken within the principles of conferral and subsidiary that impact the protection of refugee rights. Examples of such action include, for example, Dublin the Third Regulation. This EU law regulates issues related to determining the member state responsible for processing an asylum application. Thanks to this regulation, a situation where refugees would have to apply for asylum in every country they pass through has been avoided. This regulation helps ensure a more fair and coordinated asylum process, impacting the protection of refugee rights. Moving forward, a common asylum policy. The European Union aims to harmonize standards for asylum procedures, conditions for reviewing refugees, and issues related to refugee protection. This action includes establishing common definitions for refugees and persons in need of complementary protection, as well as creating norms for conditions in refugee centers. This in turn helps ensure consistent protection of refugee rights across the entire Union. Cooperation to resolve migration crises. As a part of the European migration policy, member states collaborate to manage migration crises such as the influx of a large number of refugees to the conflicts of humanitarian disasters. Coordinating action at the EU level aims to ensure effective protection and assistance in such situations. Next is the relocation and resettlement programs. The European Union implements relocation and resettlement programs for refugees to alleviate pressure on countries receiving many refugees. This action helps distribute the responsibility for protecting refugees among differing member states, thereby realizing the principle of solidarity. The mentioned actions taken at the EU level aim to ensure coherence and coordination in migration policy and the protection of refugee rights. However, the impact of this action on the protection of refugee rights can be diverse. On the one hand, the EU efforts toward a unified policy may contribute to improving the conditions for receiving refugees. On the other hand, some action, especially those related to border control, may raise concerns about human rights compliance. It's worth that the migration policy is a controversial topic, and opinions on its effectiveness and impact on the refugee rights may vary. Thank you.
Thank you very much, Julia, for such interesting answer. In fact, we can hear from you a lot of important and full of knowledge overview of the scope of the problem that I asked. So thank you very much for this. And now we are going back to Tomek for the question, what actions and regulations should be taken to counter human trafficking and exploitation of refugees effectively? Please.
Okay, so the phenomenon of the trafficking in the human beings continues to be a significant threat and needs to be tackled resolutely using a variety of the measures. It's distinguished by the rapid rate of the development, which can be compared to the dynamics crime related to the illegal arms trafficking and drug crime. The concept of the human trafficking, it's precisely defined in the provision of the Polish Penal Code. So according to this law, human trafficking is the recruitment, transportation, provision, transfer, storing, or receiving a person with the use of violence and unlawful treats, abduction, deception, exploitation of the mistake or incapacity to grasp, misrepresentation or exploitation of the mistake, and abuse or relationships of dependence, exploitation of the critical situation or a state of helplessness, giving or accepting a financial personal benefit for the promise of of a person having the care of supervision of another person. So the concept of the trafficking person is also strictly defined from the international perspective as the source of all legal norms that are the model of the national legal system. Among other, these legal instruments include the Universal Declaration of the Human Rights, European Convention of the Human Rights, Treaty on the European Union, and the Treaty of the Functioning of the European Union. Due to this geographical location, Poland has become a place of the migration for refugees, from the eastern border. Increased migration of the people seeking employment and a better living condition, bringing with the risk of the human trafficking crimes. Refugees experiencing the helplessness, financial problems, and the uncertainty about the next day will bring are targeted the criminal groups and may expose the forced labor, sex trafficking, or other forms of the exploitation. The Polish authorities make efforts to combat trafficking human beings. However, the continuous evolution of the phenomenon of the increase the various forms of the trafficking hinder effective intervention and make sure more and more difficult to combat the practice. Beside the measures taken, it cannot be said that the fight has delayed for results. In addition, due to the growth of the organized crime and other social pathologies, trafficking in the human beings has not only become widespread but also very profitable. Therefore, international human rights protection systems are important to key element in the final against this cross-border criminal phenomenon. And so, what measures and regulations should be taken to effectively combat trafficking human beings? The action, I think, is one of the most important integrated and controlled technology. The internet is a place that allows criminal recruit potential victims are more easy to various website forums. Criminals use technologies to allow them remains anonymous, making it harder to law enforcement to identify the prosecute or preparators. Human trafficking has moved into the online realm with where the victims can be sold on the boat of the so-called darknet. The next action is to strengthen the training programs for the prosecutor and judge, emphasizing the importance of the prosecuting offenders conducting proceedings with a due seriousness and taking into account the vulnerability of the victims in need to protection of the during trials, and the expanded training of the law enforcement agencies of the issues of correction in the trafficking offenses with the aim of ensuring that victims are not criminalized for the illegal acts that have committed because they have been trafficked. So the identification of the victim trafficking, especially abandoned children and migrants, should also be improved, and the development of the comprehensive assistance to victims should be pursued. For example, the creation of the specialized shelter for trafficked persons, especially minors. So to summarize my speech, human trafficking is a threat to the modern civilization. The continued effort to eradicate from our lives a huge challenge for us and the future generations. Thank you.
So, Tomek, thank you very much for this answer. A very important topic appear at our discussion, human trafficking. So I can start that within the Institute of Justice in Warsaw, we have, but we're finishing the project on the human trafficking. It's a quite important and in connection and with cooperation with the Ministry of Internal Affairs. So probably in the near future there will be a publication of the human trafficking, the comparative view of human trafficking actions against human trafficking and counteracting this problem in the Institute of Justice. So thank you very much, Tomek, for the answer. And last but not least, in this panel and in our all hard talk will be once again Agata. And once again, I would like to ask you about some question about the artificial intelligence. So, what are the implications, in your opinion, of using artificial intelligence algorithms in a risk assessment and predicting migration trends?
Thank you very much for the question. Beginning with the positive aspects. AI algorithms can significantly enhance the accuracy and efficiency of risk assessment in the context of migration. By analyzing huge data sets surrounding various factors such as socioeconomic conditions, political stability, even environmental changes, AI can provide more shaded insights into potential migration risk. This allows policymakers, humanitarian organizations, and governments to proactively address emerging challenges, allocate resources effectively, and develop targeted interventions to mitigate risks. Moreover, AI predictive capabilities have potential to play a crucial role in anticipating migration trends. Machine learning algorithms can analyze historical migration patterns, economic indicators, and social factors to calculate potential changes in population movements. This anticipation is priceless for policymakers in preparing for responding to increased migration flows, enabling the implementation to informed policies that address the specific needs of both migration and commitment in the communities. However, the use of AI in migration risk assessment also raises ethical and social fears, of course. There is a risk of reinforcing existing biases present in the data used to train this algorithm. If historical data reflects discriminatory practices or systemic biases, AI algorithm may perpetuate and amplify these biases, leading to unfair or discriminatory outcomes in risk assessments. As an example, we can point out to algorithms for determining potential recidivism, which preemptively determined as a higher the potential recidivism of Black people. It is crucial to implement rigorous measures to ensure that AI models are trained on diverse and representative data sets to minimize biases. Additionally, the ethical implication extend to issues of privacy and data protection. The extensive data required for accurate risk assessments may include sensitive information about individuals and communities. Striking a balance between the benefits of AI-driven insights and protecting privacy rights is imperative to ensure the responsible of ethical use of these technologies. Furthermore, the implementation of AI in migration prediction demands transparency and reliability. The depositors must understand how this algorithm works, the factors influencing their predictions, and how decisions based on AI recommendation are made. Establishing clear guidelines and ethical standards is essential to prevent misuse and to build trust in the deployment of AI in migration-related decision-making processes. In conclusion, while the use of artificial intelligence is risk assessment and predicting migration trends offers significant advantages in terms of accuracy and awareness, it is crucial to navigate the associated ethical, social, and privacy challenges. By addressing these fears through transparent practices, neutral data, and commitment to ethical AI development, we really can bind the potential of AI to make informed decisions that positively impact both migrants and host communities. Thank you very much.
So, Agata, thank you very much, and thank you very much for all participants in HARD-TALK, for Tomek, Agata, and Julia. So, at the end, I would like to focus, pay your attention on the fact that some time ago, at the end of the November and the beginning of the December, it was the last day of the November and the 1st of December 2023, the Central European Academy, in cooperation with the First Medal Institute of Comparative Law, organized a Children's Day, Children's Rights Day. It is a second edition of this very interesting event, and I invite you to find some information about this event on the website of the previous mentioned bodies, but especially within this great event, it was some kind of round tables, and one of the round table was children seeking asylum. that was the topic of the roundtable, and I was one of the participants of this discussion, and the moderator was my colleague, Professor Paweł Sobczyk from the Institute of Justice and from the University of Opole, so in the topic of our HARD-TALK also. And ladies and gentlemen, at the end of our event, I would like also set some important information and some kind of the knowledge for Julia for her great help and support in co-organizing this event, my dissemination event. And I have to say that that I would like to very thank you, Julia, for her help and support, for great support, and that without Julia probably it will be impossible or very hard to organize this event. So thank you very much. And at the end, ending our event, I would like to say that that is the, if I could remember, second edition of HARD-TALK. So probably I can invite you also on the third edition in next year in next hard topic, but about the another hard topic. So thank you very much, and see you at maybe at the next events and maybe at the third edition of the HARD-TALK in the next year. Thank you so much. Thank you.